Yes, Mr. Rudd.
Lord, firstly, in terms of timetabling, Friends have been very accommodating. Essentially, we've agreed to shunt everything back by 30 to 45 minutes, with me taking less time tomorrow afternoon.
That sounds very sensible. Well, no need to explain any more. Does anyone want to?
But we're still bearing in mind the Lord's direction that these are maximum times.
Yes.
Not permitted.
Good.
Secondly, on the question, Lord, puts me when I was on my feet about the information that was gathered in 2013. Yes. It's been difficult to get this over the shoulder German. One of the officers who compiled the report is still in employment of the authority, and we're hoping to be able to make contact with him this afternoon. I want to obviously give the court the accurate information as best I can.
Yes, of course.
Can I please have overnight to investigate that so that we can supply it?
Of course.
I'm sorry I'm not able to do so sooner than that.
No, don't worry about that.
Before I go on to ground two, I did promise the court that I would show the judgment of the deputy judge in the subsequent judicial review.
I'd forgotten you promised that, but I meant to read it over.
41, it's tab 41.
Other things supervened.
Can I say, Mr. Lane has handed up some additional documents.
Yes.
We have the reported decisions in both cases below, and we have the colour versions of the impact assessment.
That's very helpful. Thank you.
And I think the Lord wants also, I remind myself, the SIs that were published under that section in the Act for completeness, and I'll do those in the morning.
I don't think I asked for them. I just asked if there were any.
Right. Okay.
But I don't need to see them.
I'm not going to.
No, we've got plenty of paper. Yes.
Yeah, the Lord would have seen what happened is that subsequent to Mr. Justice Supperstone's judgment, both claimants, that case was concerned two sets of claimants, but each set individually then brought a judicial review claim against Hillingdon, in part to enforce the terms of Mr. Justice Supperstone's declaration. But in EM's case, there is also a challenge to the suitability of the Part 7 accommodation that was resolved very close to the hearing. One of those judicial review claims was heard before the Deputy Judge earlier this year. The other was due to be heard next week, but has been adjourned by consent pending.
This one was heard notwithstanding that it was known an appeal was pending?
Yes, we put an application in for a stay, but it was before permission had been granted. We did make submissions to that effect, but the judge granting permission took the view that because there was urgency in the challenge to the suitability of the accommodation.
Yes, I see. Well, don't worry about that.
So we are where we are. That was the judgment, and it was very much based on Mr. Justice Supperstone's judgment.
Yeah.
And from our point of view, as it were, without prejudice to our rights to appeal to this court. But can I just show the way that the Deputy Judge dealt with the matter? It revolved around the document that the Lord Justice Lewison has referred to, the so-called Officers' Review, which was Hillingdon's attempt to try and assess ex post facto the impact of the residency requirements pursuant to Mr. Justice Supperstone's judgment. And really, it begins at 41, the empirical evidence. And what the judge, Deputy High Court judge found was that the evidence that the Officers' Review had collected was largely inconclusive. But paragraph 42, on any basis, the total number of Irish travellers in Hillingdon at any one time is a very small proportion of its total population, perhaps something around 0.1%. Of those, some will be travelling travellers with no intention of seeking housing accommodation, some may be long-term settled. And then went on to analyse the content and the findings of the review, and I found essentially that it did not sufficiently grapple with the problem of the impact of the residence requirements on Irish travellers. And at 49 to 52, the Deputy Judge sets out the steps that she would have expected Hillingdon to have taken in order to carry out that impact assessment, which includes, for example, speaking to other traveller groups about housing issues, searching its own departments for information, internal resources, and indeed, paragraph 52, going through individual applications, albeit in a light touch way, to see what information they have. And then at 57, she gives her conclusions that on the limited limited issue before her, the review did not sufficiently address the problem. We say respectfully, there's no attempt to appeal against that because it was agreed that stands or falls on the outcome of this appeal. But we respectfully say...
So just a minute, let me just tease that out. If you don't succeed in showing on the material before Mr. Justice Supperstone that Hillingdon had justified the 10-year requirement, you do not say that the 2018 officer's review is justification.
No, because what we weren't allowed to raise on this judicial review was safety valves. We could not rely on safety valves because that was, we'd had a finding against us and it was subject to an application for permission to appeal. So the deputy judge was only looking at half the picture on our case. In an empirical way.
She was only concerned with the question, was there indirect discrimination?
It was premised, yes, it was premised on her, on Mr. Justice Supperstone's declaration that there was indirect discrimination in those two provisions. There was an attempt to assess the impact on officers, and it was quite clearly understood that we could not, in that judicial review, go beyond Mr. Justice Supperstone's findings without, because that was subject to our application for permission to appeal.
So the officer's 2018 review, just what you're saying, is not concerned with attempting to justify discrimination if it existed.
Well, it was.
Well, that's what I'm not clear about. You said you began this part of your submissions by saying that the correctness or otherwise of the deputy judge's decision will depend on the outcome of this appeal. And you told us earlier on that you were not relying on the 2018 officer's review.
No, I'm not, my lord. But what the reason we say it was this judgment is premised on the correctness of Mr. Justice Supperstone's judgment. If this court strikes down Mr. Justice Supperstone's judgment, this judgment cannot stand because it would have been an unnecessary. It depends what
about the other possibility. What if this court doesn't strike down? If it upholds Mr. Justice Supperstone's judgment?
Yeah, well then this stands.
This stands.
Yes, of course.
So then the answer to my lord's question is that you won't be seeking to rely on the 2018 review as justification.
Well, I need to be fair about this. We've not put that forward as a way of doing it. I don't think it'd be right to we say we're content to stand on our submissions in relation to the original implementation of this. We say that they did a lawful. Hillingdon did a lawful job in 2013 at attempting to assess the impact of these provisions. It was very much a try it and see and keep it under review approach, which is understandable in the circumstances. And as we will see when I get on shortly to round two, what they've produced is a scheme which must be looked at overall, and the court must, consistent with the Ealing decision, ask itself on the justification stage overall, is this a scheme that treats these classes fairly? We say it is. Can I then move to round two? And I'm going to take this fairly shortly because, respectfully, the court does appear to be understanding the issues in this case, not anticipating any more than that. at this stage. But really, I have 2 points to make about safety valves. I should just, before doing that, show you how the judge dealt with them, because I have to show that he was wrong. So if we go to the judgment, please.
It's all in paragraph 56, isn't it?
Well, it's primarily 56, but can we please also note 72. 56 is the main one, my Lord, and great. As for safety valves, I agree with Mr. Wise, Mr. Squires, not like to benefit Irish.
You have read this to us before, yes.
Yeah, and then in relation at 72, this is where the judge is dealing with the second round of challenge, which was to the working household uplift. 72. He says, in my judgment, having regard to the various safety valves in the scheme that potentially assist persons with protected characteristics of sex and disability, and the focus and limited working household uplift can be justified as a whole. There is a third mention of safety valves, and I'll come on to this when I deal with section 11. In paragraph 77, I'll come on to that. I have a separate submission on that, but essentially it's 56. And Mr. Justice Mostyn, on the other hand, accepted, the way he put it, was that there were other ways in or up. So we have different approaches from the two judges below. That was at paragraph 34, Mr. Justice Mostyn's judgment. I really want to confine this to two broad submissions, if I can. The first is that, whilst it may be understandable that on a safety valve argument we'll be looking at specific provisions in the scheme and asking the court to focus on each one, our broad submission, of course, is that this is a scheme which has to be looked at in the round. That's the ratio of the Ealing case. You look at the whole policy. And we invite the court to look at this policy as one which represents a genuine attempt by the local authority to distribute fairly a scarce resource and to cater for a wide range of groups, mixed with a number of policy aims, not least of which is to reward those residents who've demonstrated a long-term attachment to the borough for the obvious benefits that that would give rise to. And if one actually stands back in this case, or these cases, and asks, well, how does this scheme treat Irish travellers or treat refugees? Are they shut out from the scheme? No, they're not. I opened this case by looking at the interaction between Part 7 and Part 6 of the Housing Act. And that's really important because, in a sense, the major safety valve is what Parliament's put in place. If you're homeless, you get assistance under Part 7. Part 7 can now lead to a placement of suitable accommodation in the private rented sector. But if you need housing from a local authority, or an Irish traveller or a refugee, you can apply to Hillingdon, and there's a single gateway. And if you have the 10 years residence, you go through it. If you don't have the 10 years residence, but you have a reasonable preference, you still go through it. The actual difference in treatment inside the gate is banding. But once you're on the scheme, whichever band you're in the scheme, you have access to the scheme's provisions. You can be eligible for a direct offer. You can make a case to hardship. You can rely on other aspects of the scheme. We haven't looked at them in detail. There's a whole range of schemes. So that's why it's necessary to look at it generally. And it's illustrated by these cases. Neither of these claimants, when they applied, I mean, two of the cases before this court have since become technically academic. Two of these claimants are currently off the register.
When you say two of these, do you mean both of these claimants? I see. No.
I mean, I did, for the same time, I didn't go through it. I mean, the current position is TW and SW, which is the household. They're currently in a PRSO.
Yes.
I'm not going to give the address in open court.
No, it doesn't. Why would you?
They're not they're not on the register.
Yeah.
But they've invoked their review rights.
Yeah.
That's TW and SW. EM is still owed a Part 7 duty, main duty in being accommodated pursuant to that. He's on the register of Band D. And Mr. Gullu turned down an offer of a PRSO. He's still in Part 7 accommodation, but he's sought a review of the PRSO offer. That was unsuccessful. He's issued a statutory appeal, and that's to be heard on the 16th of May. So two claimants before this court have a contingent only interest in the outcome, subject to appeal review rights. EM has a more direct interest. But the way they've been treated is that they've been provided with accommodation, Part 7 accommodation. They've been put on the register. They've been put into a band on the register. EM, we've heard, Mr. Justice Underhill records, has gone to the hardship panel. So it's not a case of shutting them out. They have enjoyed substantial benefits. Now, Mr. Wise and Mr. Burton will say, oh yes, but they're not in such a high band. Well, I'll come on to that in my second point. But the first point is that when the court looks at these arguments, it should do so with respect globally, looking at the scheme properly as a whole, as an attempt to address housing needs in not easy circumstances because of the demand.
And when you say the scheme, what you
Policy.
mean is partly the scheme composed partly of Hillingdon's policy and partly of their statutory duties under Part 7.
At a macro level, my lord, absolutely right. You start off with the statutory scheme that's been put in place. I took time on Part 7 because we say Part 7 is important in this case and the interplay between Part 7 and Part 6. So the first safety valve, if we want to use that expression, Parliament's put in place for the homelessness legislation and all that follows with it. And then you go into the policy. So we link the policy with the statutory framework, and we say that that's an important factor in this case. Can I then get to the second point? And it's really a question, given that there's discrimination, prima facie discrimination, which is by no means unusual, almost by its nature, a residency condition or a financial threshold is going to discriminate against somebody or another. So it's really important for local authorities to know how they can justify. What are the options? What can be done? And this really is, we say, the nub of this case. What could Hillingdon do to mitigate or justify this discrimination? Now,
yes, they are different questions. You say to mitigate or justify. They're not two words for the same thing. You could justify it without mitigating it.
my language was loose, I apologise,
Yeah, okay.
but the reason I put it that way is because as part of justification, Ealing holds that you can look at other aspects of the policy. Mr. Justice Mostyn used the expression that the effect of those is to mitigate the impact.
I understand, but I just want to know, are you dealing with mitigation or with justification here?
I'm both. I'm dealing with justification. This is the justification defence, but I'm saying that as part of the justification, Hillingdon relies on provisions which mitigate the impact.
Yes, I don't want to, it's just, it seems to me to be important. I'm sorry I made this point just before lunch, but I don't want it to be lost. That you could justify the scheme by saying there are no available mitigations, they don't work, I accept that, but it's still justified. There will be this impact, but the impact is justified by the greater good for the community.
Yeah.
But that doesn't, we shouldn't think that just that so-called safety valves, which I think is what is meant by mitigation, is the only way you can justify.
Oh, no.
Okay.
No.
Well, okay, as long as you're aware of that.
No, yes.
Yeah,
I
okay.
understand. But however we analyse it, the practical difficulty in this case is what can the local authority do? And the only suggestion that's been put forward in these proceedings is on behalf of TW and others, that Hillingdon reduce the residency requirement from 10 years to 5. It's not clear, no doubt Mr. Myers will deal with this, it's not clear whether that means reduce it for Irish travellers alone or generally across the board. And the Commission, in its submissions, supports the claims by saying that an approach along those lines, although the Commission doesn't actually say what can be done, should be taken. Neither solution is lawful, we would say. Firstly, Hillingdon...
So we neither solution.
Yeah.
What do you mean by neither?
Neither proposal.
You've only mentioned one proposal, which is reducing it from 10 years to 5.
Sorry, the first proposal is to reduce it in relation to Irish travellers alone.
Oh, I see. Okay.
That's not lawful.
Yeah.
For the simple reason, and we've given, hardly need authority to support it, but we've given it, that would be direct discrimination. That would be directly within the wording of section 13. Hillingdon discriminates directly by giving a benefit to A on the ground of race and withholding it from B on the ground of race. And I'm just going to flag up, I'm conscious of time, not that I feel under pressure, I've made that clear. JFS at tab 10, Lord Phillips at 9. Perhaps we will just look at that, it's very short, very short. Tab 10. This was the case of the oversubscribed Jewish school giving priority to children recognised as Jewish by birth or Orthodox conversion. I'm sure all will be familiar with it. At 9, this is Lord Phillips. Separate lines down. Yet a policy which directly favours one racial group would be held to constitute racial discrimination against all those who are not members of it. Reference to Orphanus and Queen Mary College. And in the same case, Baroness Hale at 68. This means that it is just as unlawful to treat one person more favourably on the ground of his ethnic origin as it is to treat another person less favourably. 4 lines up, as Lord Kerr explains, there can be no logical distinction between treating a person less favourably because he does have a particular ethnic origin, treating less favourably because he does not. So if Hillingdon said, right, okay, well we're going to justify this by reducing it in the case of Irish travellers, that would be placing one form of discrimination by another. That shuts off that route, we say. The second route is saying, well, let's reduce it overall. I mean, that, with respect, would be a recipe for litigation. How much do you reduce it by? 5 years, 4 years, 3 years, down to what? The difficulty comes down to this. Can I invite the court to take up the Commission's submissions, please? And turn to page 19, paragraph 42.
Sorry, paragraph
42.
Sorry, I have to say it one more time. Which paragraph?
42.
42, yep.
Page 19, 42. Here the Commission is making submissions in principle on section 19, and they say for the purpose of section 19 2D, one is thus concerned not with justifying the absolute level of harm or benefit imposed by the PCP, but the relative disadvantage it imposed on those with a protected characteristic as to those compared without. A safety valve that lessens the impact of the PCP equally on both those within those without, outside the protected group, does not affect the disadvantage suffered by one group compared to the other. The difference between the two groups in terms of their ability to access social housing, obtain work, or whatever is the benefit in question remains the same. It will only be a safety valve if it ameliorates or reduces the disadvantage suffered by those with a protected characteristic as compared to those without that. They will be relevant to justification. So, on that logic, even if Hillingdon were to reduce the period across the board from 10 years to 1 month, it wouldn't be justification on the Commission's case because it doesn't ameliorate or reduce the disadvantage suffered by those with the protected characteristic. So this leaves Hillingdon in a cleft stick. They can't reduce it unilaterally because that's going to be direct discrimination. They can't reduce it across the board because that's not going to achieve what the Commission
What is
said.
the Commissioner wrong about that?
I'm sorry?
What is the Commissioner wrong about that?
Well, they're wrong.
No, what if they are wrong?
Oh, I'm so sorry.
Why wouldn't, suppose you, I take your point about where do you draw the line,
Yeah.
which is a problem you always have in this area, but suppose the court took the view that 10 years was disproportionate, using the classic test, it could have been done, you could have achieved your aims doing less value, doing less harm to the protected group.
Yes.
By having 2 years.
Yeah.
Nothing wrong with that conceptually, is there?
Well, the Commission would say...
Well, that's why I said, what if the Commissioner wrong? You don't destroy the argument by simply saying the Commissioner wrong.
Well, I accept the Lord's point, but then the trouble is we're in Ahmed territory, and we say, well... And we say a 10-year residence provision with safety valves or mitigating measures, whatever you call it, exceptions, is far more likely to be proportionate than a 2-year without.
Yes, I'm just trying to get my head around this conceptually and see conceptually what your point is. Let us suppose, just to make it difficult for you, that your policy was 20 years,
Yes.
and let us suppose that there was evidence that every other local authority in the country had had no more than 5 years.
Yes.
It would be easy enough to say that was unlawful, wouldn't it?
Well, it could be said it was irrational.
and also disproportionate.
It won't escape this court's notice that there was a rationality challenge before Mr. Justice Mostyn that was rejected. There's no appeal against it.
Okay, but we needn't worry about irrational, but couldn't we say it was disproportionate, which is the test under...
Well, it depends, because proportionality involves a range of factors. It's not simply looking at the headline, 10 years or 20 years. You've got to look at what else there is. The PCP here is not just 10 years, it's 10 years with a number of deeming provisions.
I have got, you're really repeating your point, which I've absolutely got. I'm just trying to understand it conceptually. I thought you were saying that there was nothing you could do, that you were stuck. But you are not stuck if it was disproportionate to say 10 years. If this court takes you as disproportionate to say, you're not stuck because you could have said 5.
If the Commission's wrong.
Yes.
Yeah.
Okay, I think I've got my answer. Thank you.
So, what it really comes down to, on the Commission's approach, is that...
Well, I'm sorry, and maybe if I can clarify, or I can deal with it tomorrow.
It'd be better if you deal with it tomorrow.
Well, I think the Lord has the cleft stick argument that I was submitting.
I'm making a note, Mr. Squires,
okay.
that you don't necessarily think that your argument's been correctly understood.
Well, okay.
Yes.
Lord, those are grounds 1 and 2.
Right.
What if the court is with us on those grounds? Not asking for it to be remitted. We're here now. This court is as well placed to ask itself, as it did, we suggest in the Ealing case, effectively, whether this is proportionate, objectively justified, these, and we speak for the reasons that I needn't repeat, that it is. There's also, I haven't taken the court to it for time reasons, but you would have seen in Mr. Justice Mostyn's judgment, he sets out a table of taken from the statistics in the case of the impact of the residency provisions, and I think comes to the conclusion it's affected about 55% of the people on the scheme. 45% are not adversely affected in terms of coming into the scheme. I appreciate that within banding there's an impact. But we say in terms of proportionality, you start off with a legitimate aim, and both judges have accepted that the long-term attachment is a legitimate aim. So it really comes down to proportionality. The law is that you don't look, it's got to be the least intrusive measure to achieve the aim. That's all clear law. And looked at in the whole, with the protections that are built into this scheme, and the reality that people in housing need get onto it, they don't all get housed for the reasons that Lord Justice Dyson said in the Lynn case. A reasonable preference is no guarantee of accommodation, but it deals with them fairly. I mean, in the rounds, that's our case. Can I, Lord, move on to ground 3, please?
Can I just ask one question? It's a factual question, and you may or may not be the answer. If somebody is made a Part 6 offer by Hillingdon, are they going to be housed in borough?
The answer to that will probably depend on their registered providers. Their Part 2 stock will be in borough. That doesn't have to be as a matter of law. Can I?
Yeah, I mean, it's well known, isn't it, that people who are accommodated under Part 7, at least when they apply to London boroughs, tend to be housed out of London these days.
As my Lord knows, Part 6 allocation is social housing by the local authority itself, or by what are now known as private registered providers, housing associations and the like. I imagine
I don't need an immediate answer.
I'm sorry?
I don't need to give an immediate answer. I'd quite like to know the answer at some
Yes.
point.
It's going to be different to the Part 7 situation. Okay. Can I turn then please to Section 11? Thank you. This is our ground 3. And we go to the judgment. I'm doing this slightly back to front because I haven't shown the court the statutory provision. If I could just, it's a very short passage, isn't it? No. Can you please leave the judgment open? I'll just take you to the statutory provision and then I'm going to focus on the wording of the...
Do we need more than appears in the judgment? I'm just conscious, I know you're conscious of the time. Para 19 sets out section 11.2. Isn't that all we need? Maybe there isn't.
Yes, it does. No, we don't.
Yeah, okay.
Thank you, Lord. You set out in our skeleton a number of propositions with regard to Section 11, which I don't think are necessarily controversial. It's a statutory duty to make arrangements.
So are you taking us to the skeleton or just...
Just
That's fine. If you're not taking us to it, could you just give me the paragraph numbers, not to go to, but just so for my note?
in our skeleton, it's
Yep.
66 to 75.
Thank you. Sorry, you go on.
The Hillingdon's defence on Section 11 was threefold. Firstly, that Hillingdon's Children's Services were involved in the formulation of the scheme. Secondly, that safeguarding children and promoting their welfare lay at the very heart of the scheme. And thirdly, that the scheme itself was infused with child-orientated provisions. And can I just invite the court to note, please, Melissa Murphy's witness statement, SB tab 1, paras 13 to 14 and 18 to 21, where she talks about engagement with children's services and exchange of information and so forth. What I really want to do in the time I have is to focus on the judgment and make my submissions as to how the judge fell into error. So paragraph 73, he records concessions which we made then, we make now as to the engagement of section 11, sets out the claimant's case at 74, sets out our defence at 75, and then 76, part of the ratio of his decision here, despite the Council's Children's Services engagement, so except there was engagement with Children's Services, no records or documents evidencing any action they took or discussions they had to promote the safeguard of welfare of children when the residence qualification was introduced or under further consideration. That being so, I agree, Mr. Wise, the Council is not in a position to demonstrate by reference to written contemporaneous records the process of reasoning by which they reached their decision in relation to the impact of residency qualification and uplift on the claimant's children, and then cites two cases, Queen on the application of E against Islington Council, judgment Mr. Ben Emerson, Queen's Counsel sitting as Deputy Judge, High Court Judge, and J&L Hillingdon, judgment of Mr. Justice Nickling. I'll come back to those cases. we will say in a moment that the judge has misdirected himself on those cases. 77, reject Mr Rutledge's submission that compliance is evidence from the scheme itself. He then refers to our submissions but wrongly characterises them as another safety valves argument. They weren't at all. What they were illustrations of how promoting and safeguarding the interests of children informed a number of the provisions in the scheme. And then he comes back at 78 to Ian Islington at para 114, and then 79, ratio led to the conclusion council breached their duty under section 2 in relation to the imposition and maintenance of residence qualification and uplift. And then interestingly at 80, where he goes on to the working household uplift, the judge finds that for those purposes there was sufficient engagement with children's services, which provides support for the council's contentions, albeit insufficient evidence in relation to the residence qualification, which plainly had a significant impact on the children of Irish travellers. So they're consistent with the judge's approach, we say, to ground one. He was there focusing on what the council had done specifically in relation to Irish traveller families. Now let me go back, please, to para 76, because we see that this is based on two earlier judgments. We can go firstly to the Mr Justice Nickling's case, which is at tab 38. And the reference the judge gives is para 47 of that. And what the judge does at para 47 is simply recite Deputy Judge Ben Emerson, Queen Counsel's judgment in the Islington case. There's nothing new there, it simply cites that. So we now need to go to the Islington case to see the source of Mr Justice Supperstone's judgment here, and that's at tab 40. Can I at this point just lay down, I've made about this in reply if necessary, or deal with it in reply if necessary, just lay down a very important point here when looking at section 11. Section 11 has been held to apply both to policy formulation and individual decisions. Caution must be exercised when looking at decisions on individual decisions. The Nazella Messo case is a classic example. That was the case that went to the Supreme Court on the lawfulness of Westminster Council's decision to place in Bletchley a Part 7 applicant, an out-of-borough placement case. And the reason you have to be cautious is because those cases are decided under the Part 7 framework, which requires the local authority to give a reasoned decision. That's why I took the court to it early this morning. So it's important not to read, as it were, the Part 7 obligations. And that's what appears to have happened in Ealing. If we go to 114, paragraph 114, which is the source of Mr Justice Nickling's judgment and relied upon expressly by Mr Justice Supperstone in our case, 114, not have it. We see that it's based upon what Baroness Hale said in the Zellamesso's case at 31 to 35.
What What is the question which he says that she addressed?
Well, I'm coming to that now. I just want the court to see what Mr. Emerson says.
Yes, I see that, but in order to see it, I need to understand what she means in the first line that he quotes. But don't you keep going, I expect I'll find out.
I'm so sorry. Well, I think it's that he's digressed at this point. It may be easier when we put in context. But the point I was making is between C and E, we get the references to the duties in order to minimise educational corruption, to record reasoning, to be in a position to provide evidence of contemporary reasoning in court, if called upon to do so, and so on and so on. They're all the matters that Mr. Justice Supperstone relied upon, the procedural requirements said to arise out of Section 11 that Hillingdon had failed to do in relation to the residency.
Don't take that as a comment on any of the issues, Mr. Roberts.
The residence provision, but not in relation to working household. Can we go then to the source of that in the Zella Meso?
What was the challenge in Islington? This was a care assessment. This wasn't an attack on a policy. This was an attack on a decision.
Single decision, out of borough placement.
Under Part 7.
Part 7, exactly. Yeah, but there was also a Section 11. I think Mr. Wise will correct me, although we were both in the case.
There seems to be a judicial review, which wouldn't be a Part 7 appeal.
No, it was actually a claim for damages under the Convention for deprivation of education or breach of the statutory obligation under the education. It was a complex case. Essentially, it was an out-of-borough placement by Islington of a family of a claimant who had severe disability and who was fleeing domestic violence in circumstances where, although the necessary notification was given to the host borough, no further information was given. But that part of the case engaged Part 7 duties. But if we can go to the Zella Meso, where was it? Which is in tab 1, volume 1. 15. Tab 15. And we look at arrows 31 to 35. Firstly, before I get there, can I just take you, please, to 22 under the subheading the children's welfare. This is the out-of-borough placement case. See that Shelter Children's Services have intervened to remind the court of the local authority's functions under Section 11.2. So there's an intervention by Shelter Children's Legal Services to raise Section 11.2. There was also an intervention by the Secretary of State. The short point is this, that whereas Baroness Hale is looking at Section 11 from paragraph 22 to 30, at 31 she then turns to the intervention by the Secretary of State for Communities and Local Government, which has nothing at all to do with Section 11. It's all to do with the code, and that's a reference to the Homelessness Code 2006, see that paragraph 14, and the supplementary guidance, which we see at paragraph 18, the so-called concentric circle guidance. So everything that's said that Mr. Emerson picks up and converts into this list of duties about record keeping. It's all said in the homelessness context in relation to a code of guidance and a supplementary, a code and a supplementary guidance concerning a completely different statutory scheme. So the judge has misdirected himself as to the nature of the duty under section 11. But and then he's mischaracterised Hillingdon's primary submission that you've only got to look at this scheme to see that children lay at the very heart of it. It's a scheme, so far as is possible, to provide accommodation for households, and where there are children, to include those children. We've set out in our skeleton a number of specific references. It's not a safety valve argument at all. It's an argument to demonstrate compliance. Do we have to say explicitly that we have done that under section 11? No, of course we haven't. And to make good that submission, can I take the court, please, to MacDonald, which is tab 11. Decision of the Supreme Court. This was a community care case. This was the case where the local authority was challenged for its decision to offer incontinence products to a client who was not clinically incontinent, but to do so as a way of essentially reducing cost and also to better respect her privacy. And one of the issues raised in that case at page 1279 of the law report, this is the judgment of Lord Brown, with whom all other members of the court agreed except Baroness Hale. And it's an argument that the local authority had failed to have regard to section 49A of the Disability Discrimination Act 1995, which was the predecessor of the PSED, current PSED, and it's paragraph 24. The argument we see at 23 is that because there was no express reference to the PSED in the documents, it should be inferred that they hadn't complied with it. Paragraph 24, this argument too is, in my opinion, hopeless. Whereas here the person concerned is ex-hypothesized disabled, and the public authority is discharging its functions under statutes which expressly direct their attention to the need of disabled persons, it may be entirely superfluous to make express reference to 49A and absurd to infer from admissions failure to do so of a failure on part to have regard to the general duty under that section. That I'm satisfied with the position here. The question is one of substance, not of form. There was evidence before the judge of engagement with children.
Well, that's the mirror. This is Mona Lisa.
I'm sorry?
This is the mirror of Mona Lisa. Here you've got a client-specific decision. The authority knows she's disabled. So of course they're taking into account her disability. The reason it's different from Puretti and Enfield is that in Puretti and Enfield they were producing a policy, borough-wide policy, and hadn't taken into account the possibility that the Purettis might be disabled, I think. And though Miso was a single instance decision, the remedy for which was, according to Lady Hale, have a policy.
Lord,
So you're also mixing the two, aren't you? No?
I hesitate to say this, but respectfully, Lord's wrong about Puretti.
Oh, I like it.
I was in Puretti,
Right.
although I was described as being wrong on 3 occasions in the course of Lord Justice Wilson's judgment. But that was a Section 204 appeal, an intentional homelessness decision. And what the local authority had not done in that case was to look at the disability of Mr. Puretti in reaching the decision. And in fact, one of the arguments on which Mr. Rutledge was wrong in that case, and it was an early case to be fair, was that the PSED duty was limited to strategic decisions and not individual decisions. So it was the converse of that. But I put it forward simply to show it's an obvious point that you only have to look at this. But in fact, the point Ms. Murphy makes, and I can end on this, is so weighted is this scheme towards children that they have included an uplift for childless couples.
Uplifted.
An uplift, band uplift, under their powers.
I just didn't hear what you said.
Absolutely. They've included a band uplift
Yeah.
for childless couples. It's one of the uplifts. There are a number of
I've probably been very slow. How does it show that it's a child-centred policy?
Well, because
you have a band uplift for childless couples.
Because those who don't have children obviously feel that the priority is given to those who do. That's the point she makes in the witness statement. In my respectful submission, it's a fair point. I said 30 to 45 minutes. Can I? Yes, that's right. Yes, yeah. Mr. Day helpfully reminds me that Mr. Justice Supperstone, on the working household uplift, found in favour of Hillingdon on the children point.
Well, you made that point already.
Yeah. Can I have a moment? Just really other questions.
Thank you very much. Right, well, according to the time, I think we're hearing from Mr. Burton next.
Lady, my lords, yes. I wonder if I might just have one moment just to arrange the papers so that I don't have to
Yes, you have
record,
this.
if I can. Yes, thank you.
You've got a space.
Yes.
My lords, my lady, this obviously is an appeal on behalf of Mr. Gullu, who is a refugee, but the overlap between the two appeals is something, of course, the court have already remarked upon. And so, in the course of my submissions this afternoon, which I've modified to some extent in light of the interaction between the bench and my learned friend, I'm going to try and address some of what he's already said, to try and narrow the issues in the best way that I can.
I'm sure that'll be very helpful.
Before I do that, I wondered if I might just make some more general observations, which are really just scene setting and are really designed to do the same thing, which is just to draw the focus to what's really an issue, at least in my submission, in Mr. Gulu's appeal, and will to some extent, I anticipate, reflect what I believe to be an issue really generally in these appeals.
Yes.
So, as I've already said, this is a claim obviously brought against the residence criteria on behalf of refugees. Refugees both as a member of a particular racial group, which is non-UK nationals, but also in their own right as refugees, because the disadvantage that UK nationals suffer, which is they are disproportionately less likely to meet the residence requirements, is deepened in the context of refugees. Why? Principally because refugees have no choice about leaving their country, that much is obvious enough, but indeed they have no choice about where they live when they come to the UK, when they are seeking asylum. And the relevant references are all in the skeleton argument. I can take the court to them if need be, but this is all common ground. Under the asylum support regime, which is bound to be necessary for most refugees, because of course they're asylum seekers, because they are prohibited from working, there is a no choice rule or primary legislation which prevents the Secretary of State from honouring any request to be accommodated in a particular area. On top of that, the evidence from the Refugee Council, Ms. Chloe Morgan, it's in the bundle again, this is not in dispute, demonstrates that not only will the Secretary of State place a particular asylum seeker in an area that is convenient from the Secretary of State's perspective, but an asylum seeker may be moved several times in the course of their period of occupation through the asylum support regime, accommodation, I should say. Moreover, that is then reflected in the homelessness provisions. The evidence of Ms. Chloe Morgan again demonstrates that at the tipping point where an asylum seeker becomes an established refugee, of course they're always a refugee, but the point where it's acknowledged by the Secretary of State that they're a refugee, they lose that support within a 28-day period. Theoretically, of course, they're now able to work and receive mainstream benefits, but the reality is that most of them are homeless at that point, and indeed the evidence from the refugee...
Sorry, you're letting your voice drop.
I do apologise. I wonder if I might just ask for some water. And maybe a glass. Very well prepared, sorry. The point I'm seeking to establish is that there is a critical moment when a refugee is accepted as such by the Secretary of State, where the asylum support comes to an end, and they are highly likely to be homeless, and therefore they're likely to make an application to local authority as homeless. And importantly, at that point, again by statutory deeming provision, they are said to have a local connection with the area where the Secretary of State happens to have accommodated them.
Yeah.
What that means in practice is unless they can establish a local connection elsewhere, which in light of their circumstances, and in particular the fact that they've come to a country normally without any established ties, is unlikely, it means they are effectively tied to the local authority area that the Secretary of State happened to accommodate them within. Now, why do I say that deepens the disadvantage? Well, one, of course, the obvious point is that they have even less choice about where they live than a non-UK national whilst they're in the UK. But also, in my submission, it makes the application of a rule which is explicitly designed to reward a particular type of choice, namely to remain resident within a particular area, unfair. Because it presumes the making of a choice that was never, in fact, ever open to an asylum seeker to make.
I'm not entirely clear, Mr. Burton, how this fits into the Equality Act claim as opposed to the Article 8 claim.
It's a very astute question, if I may say so, and my best answer is as follows. The Equality Act discrimination claim rests on the difference of treatment between non-UK nationals and UK nationals,
Yes.
which, as we now know, is established and accepted as being present. And then the next question is whether or not it's justified. It's absolutely right to say that the tenor of my submissions on behalf of Mr. Gullu throughout this case has been on the obvious lack of justification in freestanding terms of applying this rule to refugees rather than necessarily the broader class.
So you say, do you, that in looking at the disadvantage suffered by the broad generality of non-UK nationals, which is your pool, you are entitled to concentrate on a smaller group within the pool, namely refugees. Is that how it fits together?
Not quite, if I may just put it this way. First of all, just for the sake of clarity and just to avoid any confusion later on, this isn't really about the pool, this is about the affected class who share the relevant protected characteristic, which is the racial group non-UK nationals.
Yes.
The pool is everybody else who's applying for housing from London Borough of Hillingdon. It's absolutely right that refugees are a subgroup of that affected class. And it's a subgroup with a extenuated form of disadvantage.
With the what form of disadvantage?
Exacerbated.
Wasn't picking you up, I just didn't understand.
Yeah, I think I used the wrong word. I may do that several times in the course of the next hour. Now, it may have been a simple answer for the borough to say, well, how does the disadvantage suffered by refugees bear upon the question of justification in the context of the broader class? And the obvious way, in my submission, that might have been done is by saying that they form a small percentage of the broader class. In fact, as I'll come on to demonstrate, the likelihood is they form a very significant part of the broader class because they are one of the few groups of persons from abroad who are eligible in the first place to be considered for an allocation of housing. And if it's right that they form a very significant part of the broader class, then naturally, if it's not justified in relation to refugees, it's highly unlikely to be justified in relation to the broader class. So let's, by way of an example, for the purposes of argument, let's say it was established that there were 10 non-UK nationals who were disadvantaged by this rule, and 9 of them transpired to be refugees. And the argument about justification was to some extent dependent not only on the fact of them being non-UK nationals, and of course there's a degree of overlap in that regard, but also the specific features relevant to refugees, then there would be no difficulty in my submission if the court was prepared to accept that it was unjustified in relation to refugees, to say, well, it's plainly not justified in relation to...
Funny way of putting it, but it's the wrong... Just assume the facts are, as we're hypothesising, that 90% of all non-nationals affected by this policy are refugees. Justification is ultimately a balancing act, a balancing exercise. Is this your submission, that if a factual characteristic of the affected class is that most of them are people who suffer particularly heavily from this policy in terms of its impact, in deciding whether the policy is justified, you've got to look at the kind of people who are in the class, not just at what defines the class.
My Lord has the point,
I'm not sure it's right, but that is what you're saying.
in my submission, it must be right, because of course what the disadvantage is concerned with is what takes place in fact.
Well, what takes place in fact because of the protected characteristic?
Well, because of the I mean, one mustn't get too involved in the reasons why.
No, I don't mean because of in that sense, but...
It may not matter at all. I mean, I should preface this by explaining why it may not matter at all. But insofar as it does matter, it's my submission that there are good reasons to believe that refugees will form a very significant part of the broader class. And it's only, of course, in the circumstance that the court feels it's something particular about refugees that tips the balance. Now, in my submission, that's not necessary in this case for the following reason, that the defence that has been advanced by way of justification by the borough is effectively the same for the entire class, which is that the safety valves do enough to offset the disadvantage, putting it broadly. And the evidence of those safety valves is, with respect to the borough, no better in relation to refugees or other non-UK nationals. And so, insofar as the court might, on that basis, be inclined to reject the defence, it plainly then would encompass refugees at the same time. And then it would be a question for the borough, when looking at the question of remedy, whether or not within the class it wanted to deal with the worst cases of disadvantage.
Can I just... I see how you put it conceptually, but I haven't quite understood why you say refugees suffer a deeper disadvantage, I think that's the way you put it, than ordinary non-UK nationals who can't comply with the residence requirement. I take your point that they won't have had a choice as to where they lived. This won't be the result of a lifestyle choice, but that will be true for most young adults, for example, because they won't have chosen where they lived for the last 10 years. That would have been dictated by their parents. There may be all sorts of other reasons why UK non-nationals haven't had much of a choice. You're looking at the moment where the policy bites on them. I can't quite see why being in Band D is any worse for a refugee than for any other homeless person.
Well, first of all, it's built on top of the pre-existing disadvantage, which is having a tendency to fall alongside of the rule generally in the same way as non-UK.
Sorry, say that again.
it's built on the established and accepted disadvantage, which is by being a non-UK national, they're more likely to be on the wrong side of the rule in the first place.
But you're saying, yeah, of course that's right, but your whole point, you've all started with saying that refugees are in a special position within that class, and I just quite get you to define why.
Yes, with the purpose of simply demonstrating that the disadvantage experienced by them is even greater.
But why?
Because the extent to which they can make freestanding choices about where they live within the UK.
But that's how they got to be in that situation. That's your point, is it?
Well,
it's not that it's any worse for a refugee to be on Band D than it is for a homeless non-UK national who isn't a refugee.
No, by having a restricted choice, they're even more likely to be in Band D because they have not had the opportunity to exercise the sort of choice.
But that's in the past. They can go somewhere else, but they'll be in the same problem if the other local authority has a similar policy.
Yes. As I say, this is exacerbating pre-existing disadvantage by applying a rule which is based on choice in circumstances where the person didn't have a choice. Whereas, for example, another form of non-UK national, or indeed person from the UK coming to Hillingdon, would always have the choice to go back to where they came from, if indeed that's what they wanted to do. They're not stuck with Hillingdon in quite the same way. So the logic of the reward mechanism that is explicit in the residency rule just doesn't work in the same way in relation to refugees. It may be unnecessary to go into this. It seems, in my submission on the facts, unavoidable that if you are going to say to a particular class that you've got to meet a residency requirement that is by definition more difficult for them to meet because they're very unlikely to have been in the UK at the same time as UK nationals, that disadvantage has worsened in circumstances where they can't, as a consequence, go back somewhere else that they have a right to go to. Or indeed...
once they become refugees, which is the point we're concerned with, they can go anywhere in the country.
Well, my lord, that's where there is a genuine distinction between refugees and others, because if they need to avail themselves of the homelessness provisions, which they may well have to do because of the drop-off point, they are tied to the area that the Secretary of State...
Well, perhaps we're spending too long time on this, but we're comparing them, say, with a Lithuanian, or no, I better say a non-EU, not sure this is relevant, but comparing them, say, with a US national with leave to remain. Why are they in a worse position? The US national.
Well, it's simply that the impact of the rule is one where, from the refugees' perspective, having now had no choice about where they live, and now being required to make a homeless application in local authority area A, and then being told, well, because you haven't been able to establish your loyalty to this area, you're not going to be given priority under the scheme. They are stuck with staying where they are and trying to make do. Whereas at least the alternative, in the case of either an American or someone else from some other part of the UK, kind of weighed that up in the balance when they made their decision about where they want to live and gone, right, well, I'll have to go back to where I came from and perhaps make good there. So it's simply
where they came from, unless they happened by chance to have been in that place for 10 years, they're no better off.
Well, I fear we may be straying into the territory of picking up examples which are a bit similar and saying, well, it doesn't seem that different. Of course, there will be examples in those groups who have shared similar experiences to refugees in the sense that they may have felt they had less choice about where they were going to live than refugees. But with refugees, it's a statutory compulsion that they are denied that choice. And that's really only the point. It's exacerbated pre-existing disadvantage. And the real relevance of this is simply to say that, and it was raised really within the context of what I was about to say about remedy, which is that we've heard quite a lot from my learned friend about the impossible position the borough would be in if it had to accept that there was discrimination in the context of Irish travellers, and as I understand it, his submission carries over to non-UK nationals. One of his submissions is, well, that would necessarily require them to positively advantage on the grounds of race one group to the detriment of another, which would be unlawful in itself. Now, whether that's right or wrong, it wouldn't apply to the sort of measure that is essentially the focus of this claim, which is that when looking at how to, if you like, deal with the worst instances of unfairness in terms of the application of this rule against non-UK nationals, the local authority could say, well, it's refugees in particular who seem to be getting a rough deal for the reasons that I've elaborated. So even if they're not necessarily, by virtue of the rule, less able to comply with it, they're still less likely to comply with it than UK nationals. There is still an element of unfairness in applying a rule to them about choice when they didn't have that choice to make in the first place, which might be remedied by some form of moderation or exemption for refugees that might not necessarily apply to other non-UK nationals.
Just see that for a moment. If you succeed on discrimination against non-UK nationals,
My lord.
which is a group with a protected characteristic,
My lord.
you then say, is this right, that one possibility is that Hillingdon could make and relax the requirements for refugees, and as refugees do not share a protected characteristic, that would not be unlawful discrimination under the Equality Act. Is that how you put it?
That's correct. It's a matter of law, yes. Another way of looking at it, if I may put it this way, is, as we all know, in order for discrimination to be established, the rule in question does not have to affect every member of the class. And that may be capable of being determined not simply by reference to the individual circumstances of the individual members. It may be capable of being determined by reference to some other factor, which is relevant to distinguishing one member of the class from another. That's precisely what we have here. It's not necessary to establish discrimination that every non-UK national is going to fall the wrong side of the 10-year residency rule in order to establish that it's discriminatory, because in general they are less likely to meet the requirement than UK nationals. When it comes to trying to remedy that, the approach that one might take, if one were the relevant decision maker, is to say, well, let's focus on the examples where the disadvantage is most acute. We certainly don't have to remedy the problem for people who aren't affected by it at all, even though they share the protected characteristic. So crafting a rule which is designed to meet the worst aspect of the disadvantage caused by the rule is a perfectly legitimate way to address the problem. And it is a stark fact in my submission that refugees are an acknowledged vulnerable group with particular circumstances who are also, unlike many other persons from abroad, granted eligibility under the scheme in the first place. And there is nothing in that submission, if I may respectfully say so, which detracts from the general proposition that the discrimination against the broader class, non-UK nationals, is established, even if ultimately one can envisage a lawful remedy to that problem, which only deals with a subgroup of the class. It happens all the time. And I make that submission because it seemed the argument that was being put against Mr. Gullu on remedy was, well, it's a problem that can't be solved. Because the only way you solve it is by granting an exemption to non-UK nationals as a whole. And non-UK nationals are a racial group. And I don't accept that premise, but also it would be inconsistent with the submissions that are made. So it's not necessary for this court to find, if I may respectfully say so, that the capability of complying with the rule is any less on behalf of refugees than other UK nationals. would be my submission that on a fair assessment of facts, refugees are likely to be more unfairly impacted, if one can put it that way, by a rule which effectively denies them a reward for not having made a choice that was never theirs to make. The reasons why I principally say this is probably only going to be relevant to remedy is because of what I've already said, and I'll repeat it once more, and I hopefully won't say it again, that the borough's defence to this claim is the one that the court are required to consider, and the borough have invited the court to find that it's the other aspects of the scheme that allocates social housing which remedy or make justified through mitigation, and that was a submission, the discrimination against non-UK nationals justified. That's the focus. Now, if the court finds, it would be my submission to the court, you will be compelled to find that as a question of fact, those safety valves don't assist non-UK nationals at all, and there's no evidence that a single one has been assisted by any of them. Then in those circumstances, the defence has to be essentially rejected because no other defence has been put forward for justification. There's been no argument, for example, that if a lesser requirement or a different requirement were applied to non-UK nationals, that would undermine the objective of the rule, which was to reward, in general, long-term residents in Hillingdon. Now, the evidence about the extent to which that rule is resulting in housing allocations going to people with long-term residence is very strong. It's at the very least over 50%. And so some modest adjustment in the context of refugees, it now being, or indeed non-UK nationals, it now being acknowledged that there's a difference in treatment that requires justification, would, in my submission, very plainly not significantly undermine the broad purpose of the, or broad objective of the rule. And what we haven't heard from Hillingdon with respect in the evidence, or indeed in the submissions, is why that's wrong. Why would a modified rule or an exception to the rule which reflected the circumstances of non-UK nationals, or in particular refugees, for the reasons I've outlined.
Sorry, I'm probably being very
A rule which reflected the circumstances of non-UK nationals, or indeed refugees, undermine the broad objective of the residency requirements, and in my submission it plainly wouldn't.
Is it unfair to ask you, perhaps you'll say it's in your submission somewhere, what sort of modified requirement or lesser requirement are you speaking of?
Well, there has never been an explicit suggestion by Mr. Gullu, because it's ultimately always going to be a matter for the local authority, and if one suggests something, then one doesn't have the evidence, which is really the problem in this case. I mean, the real problem is an epistemic one. We just don't have the evidence which allows us to explain why the justification is made out. But the sort of rule which one might think would cater for the disadvantage that refugees suffer is one which sought to reflect the fact that some refugees are placed in Hillingdon through no choice of their own, but may establish a connection with the area in any event through that placement. But it's unlikely to have been 10 years, because they're not even going to have been in the UK for 10 years. And the purpose, in fact, of the Secretary...
Sorry, you're explaining why, but you're actually saying what?
Well, there would be other ways in which...
Such as? I take your caveats, but I thought that subject to the caveats, you would need to give us some suggestions.
Well, there would be... I don't want to descend too much into the practical, but one could certainly say there are other ways in which one could test whether or not they'd establish a connection to the area, without having to require of them the impossible, which is 10-year residence in the area. So, for example, you might say that somebody who was placed in the London Borough of Hillingdon by Secretary of State for a period of 2 years would, by default, have established connections there in circumstances where they can't establish connections.
Well, it doesn't matter whether they were placed there. The fact is they would then have been resident there. So you're simply saying a lesser period.
That's one very strong candidate.
Right, okay.
I just don't want to push it too far because then we end
Well,
up...
all right, but I think forensically it's quite helpful if you do press it further. You don't have to commit yourself, but one possibility is a lesser period.
Certainly
Anything
not
else?
a lesser period. And a lesser period perhaps demonstrated by other factors such as having a support network there or having medical support that one is closely connected with, perhaps establishing some form of social community life in the area, such as is consistent with somebody who has, done their best to develop ties in an area that they didn't fundamentally choose to live in. And that was, just by way of an example, the sort of conclusion that was reached in the MM case in the Upper Tribunal by Judge Kate Marcus QC, who was dealing with a 2-year residency requirement.
So which is the name of this case?
That's MM, which is...
On the facts, though, isn't this going to be a very rare case? The evidence seems to be that asylum seekers are very, very rarely placed in London. Mr. Gullu is an exception because he was receiving treatment relating to the effects of torture. But the vast majority of asylum seekers are placed in accommodation outside London. As you've explained, if their applications for asylum are successful, they lose their housing support as asylum seekers and become homeless. But as you again explained, they are in effect tied to the place where they have been housed as asylum seekers, which almost by definition is outside London. So the number of refugees affected by Hillingdon's policy must be very, very small, mustn't it?
Well, one can make assumptions, but one doesn't know, and that's obviously one of the principal arguments on the justification defence, is that we don't know. But that may well be a very safe assumption, in which case, were there to be some accommodation of those circumstances, which didn't require the impossible, then one could plainly see that it wouldn't significantly undermine...
Maybe 5 or 6 people a year were affected, it can't really undermine the objectives.
Well, not exactly. And then we wouldn't be in this case if there were a specific rule contained within the scheme which could in some way tailor itself to those circumstances, but there is not. That's really the key point.
Yeah.
So had the local authority said there's far too many, we couldn't accommodate it without undermining the rule, that would be one thing. That's not been said. In fact, what's been said is, initially, the scheme doesn't discriminate at all, because anything that is a disadvantage by reference to the residency requirements is offset by other provisions. But in fact, the evidence suggests the opposite is true. Not a single refugee has been assisted by any of those requirements.
Mainly because there are very few. I mean, that doesn't really get you anywhere.
Well, another way of looking at it is to look at whether or not any of the rules of safety valves on their face assist. And the only one that's really been put forward seriously is the hardship provision, and I deal with that in the skeleton argument. But hardship provision is really dealing with something altogether different, hardship. And this is not about hardship, this is about reflecting the circumstances that refugees in particular are confronted with. Just for completeness, there were 2 other refugees who were referenced in a letter that was before Mr. Justice Mostyn, who were also placed in Band D and weren't given any kind of special uplift to reflect their circumstances. There were 2 other refugees, I do apologise, who were acknowledged in the evidence, a letter from a different solicitor's firm who said they also had 2 clients who were refugees who were also placed in Band D. So there's a bit of evidence about numbers which might offset to a degree what's said about the criteria. And, just to finish on that, if I may, the evidence from the local authority officer is there's never been a refugee who's met the hardship criteria, so, which is not the same thing as saying there haven't ever been any refugees who've applied for housing from Hillingdon.
Could I just ask, sorry, one rather tangential question. We have a list, I think, for the 2016 consultation of all the people who were consulted. I did look through actually to see if there were any Irish traveller associations. I didn't look to see whether there were any refugee bodies consulted. You don't have to know have that.
The letter from that list. It
Yeah.
seems the letter went to the Refugee Council, but I don't know if they responded.
Yes, I see.
Interestingly, in the course of the consultation, somebody did raise the potential implications of the rule on asylum seekers. And often people get confused between asylum seekers and refugees. And the simple answer given by the borough in its officers' report was, well, they're not eligible for housing at all. And unfortunately, it was a golden prompt to say, well, wait a minute, actually, what about once they get refugee status? What if they're in Hillingdon? What can we do, if anything, about them, acknowledging, as we must, and this is how one would say it ought to have gone, that they're likely to be very significantly disadvantaged by this rule, because not only won't they have lived here, they haven't got anywhere else to go. But my lord, just to complete the submission on the question about whether or not these safety valves are relevant in the context of this particular disadvantage, as I've already said, and we've had the exchange about what the evidence says, which is it hasn't helped anyone so far. It's also, in my submission, very obvious on the face of those exceptions that they couldn't offset the disadvantage that we're dealing with here, other than by requiring something altogether different, which is hardship, and that would be simply to put a further hurdle in front of somebody who shares these protected characteristics. And it's not the same thing as trying to sort of, as it were, level the playing field to some extent in the context of the residency requirements. So that was the way in which I was trying to, as it were, frame the appeal on behalf of Mr. Gullu in terms of what the issue is about and what the ultimate remedy might be. I was going to make just a number of other brief observations about the nature of the claim before I moved on to the grounds, which I can be relatively quick on now because at least one of them has gone, and we're only really dealing with justification now, and we know what the issues are in relation to that. I just wanted to make a point about scarcity of resources here too, if I may. It's obviously absolutely right that there isn't as much social housing in the London Borough of Hillingdon as there are people on the list. But it is perhaps noteworthy that the evidence before Mr. Justice Mostyn, at least, is that it's moving in the right direction. The discrepancy between the people on the list and the people who are being accommodated is going down, which in the submission of Mr. Gullu is supportive of his case that some form of modified rule for refugees would not significantly, if you like, disturb the balance of the scheme. And just to give the court a reference for that, I may. It's in the supplementary bundle that applies only to Mr. Gullu's case. And it's the last tab, which is the evidence of this mercy.
Sorry, where did you say?
Sorry, it's in the Gullu supplementary bundle.
Yeah, I've got that. Which tab?
Paragraph 10.
Paragraph 10 of what?
Sorry.
Ms Murphy's updating statement.
Indeed, my lord, yes. The last tab, which is tab 13, I do apologise. I think I said tab 10, I meant paragraph 10.
Could I have a yellow highlighting pen?
I have a vague memory, Mr. Burton, that somewhere in these papers it might have been one of the equality impact assessments. the officers said that if the policies were implemented, then the imbalance between supply and demand would be eliminated within a few years.
Yes, it's my lord has it exactly right. It's the 2000. It's the impact assessment, not the equality impact assessment, which is behind tab 2.
Of which bundle?
Sorry, this is down the joint supplementary bundle. Behind tab 1. It's the very last sentence of the impact assessment. So it's page 20.
Yes, what was I having in mind? There could be a surplus of supply.
Yes.
Must be a first for anyone.
Well,
Just
sorry,
actually,
I'm behind. I've got the document. Which page?
it's page 20, and it's the very last sentence, save the one under action. Sorry, they're both action. The penultimate action, last sentence.
Yes.
But in large measure, it's not because there's more houses or anything. In large measure, it's because of the drastic actions that have been taken to reduce the number of people who are going to be eligible, isn't it?
My lady has a point, absolutely. But
So how does that affect your point about no harm's being done because they're doing fine anyway?
Well, I'm not going nearly as far to say no harm is being done. I'm just trying to put the issue of supply in context, and only making the point that the numbers are the borough's attempt to get a smaller list is working, and the waiting time is being reduced because the overall size of the list is reducing. I'm not suggesting, I can't say that there's a surplus. That may have been envisaged there, but it obviously didn't materialise. And of course, just to be straightforward about this, that it's the very fact that there is scarcity of resource that makes this case so important in my submission. Because it's only in the context of something which can't be given to everybody that one has to be very careful that one creates rules which are not discriminatory. Obviously, if there was no scarcity, then everybody would be perfectly entitled to get their social housing and there wouldn't be an issue. And in my submission, that's really the proper approach. And that's the approach adopted by Lord Hope and Lord G, and then accepted by Baroness Hale and others, and I'll take the court to citation in a moment. But it's really, even in the context of socio-economic matters, it's the scarcity that drives the need for vigilance about discrimination. And it's particularly why, in this context, in the context of both Irish travellers and refugees, it was incumbent on the local authority in the submission of the appellant and the respondent in DW appeal that specific consideration should be given to two groups who are obviously going to be affected by the residency requirements. They're not, if I may say so remote in terms of their characteristics from the circumstances of the residency requirement to mean it would be unrealistic to have expected a local authority to do that. They're absolutely the sorts of category of person the local authority should have been thinking about. One who is nomadic by definition and then is unlikely to be resident in the area, and then non-UK nationals who are also unlikely to be resident in the area, particularly refugees who are of that group of non-UK nationals, the ones who are going to be in the first place eligible for support. And really ultimately that's what these appeals are about. It's about whether or not, having regard to the material that's before this court, it can be satisfied that the defence of justification is made out, or whether or not it's appropriate that this discrimination should stand. And my only submission really is that the simple answer to that cannot be, oh, because the resource is scarce. That's the very reason we need to be careful about the rules that are designed to distribute it. And none of this, of course, is a criticism. I mean, my learned friend said several times that the scheme was a genuine attempt by the borough to come up with a system to distribute that scarce resource, and that's absolutely right. And if it were the case that we were asking for the impossible, then there would be a point for my learned friend to perhaps make about that. But in my submission, for the reasons I've just outlined, we're not asking for the impossible. We're actually really asking for a fairly obvious, in my submission, potential implication of this rule on two groups who are particularly vulnerable and acknowledged as such. And that's all that this was really about.
And would you say that the consideration of non-UK national stroke refugees ought to be in the spotlight for every local housing authority in the country?
Well, again,
Does the fact that Heathrow Airport's in Hillingdon make any difference? So, I mean, if it was a Totnes District Council, would they also have to be equally aware?
well, in the Winder and Samwell case, the court in that case accepted a submission by Mr. Drabble QC that it ought to have been, at least in the mind of the decision maker, that if their rule, which is a 2-year residency requirement, were replicated nationwide, it would cause very significant problems for people who couldn't establish that residence, non-UK nationals in that context. So in my submission, it would be appropriate to have regard to the possibility that if such a rule were replicated nationwide, it would cause very significant problems for refugees. But I don't believe we need to get into that in this case, of course, because again, we really come back to the same problem, which is the absence of information here. We just don't know how many refugees are affected. And we just don't know whether or not a rule which keeps them out in the way that this rule does is affecting a high number or a low number.
How much does that really matter? I mean, the problem arises anyway. Who does it help to show there are a lot or a little?
Well, it all depends on what justification defence is put forward. That's really the essence of it. I'm doing my very best to address a very good question, if I may say so, from my Lord, about whether or not this would apply to every local authority, and I can't answer that because I don't know what unique circumstances in relation to refugees pertain in Hillingdon. All we've got is really a single element to consider, which is what do the safety valves do in this context? Because that's the defence that's offered.
And how is it open to a local authority to discover the number of refugees in its area?
Well, the answer to that's very straightforward, in fact, because, and I can take the court to the relevant regulations in a moment, that non-UK nationals or persons from abroad are ineligible for support unless they can establish they're eligible. And the first class of eligibility is refugee status. So in order to even get to the stage of being entitled to get on the scheme, they need to say, I'm a refugee.
So that might yes, I was wondering whether the position was different in 2013 and 2016 from that point of view, but not. No.
And the 2016 review took place after this claim was pending. This claim was issued before then. The first kind of challenge being that because there was no exception for reasonable preference groups generally, then there was a statutory breach even before we got onto discrimination. But the local authority have known for some time what the issue is, and they haven't decided as a consequence to adduce evidence which says, well, this is what it would mean if we were to give a lesser.
Yes, I think what I was thinking was that until 2016, refugees who were well advised wouldn't bother getting on the list because they would know they couldn't satisfy the residence requirement. So you wouldn't have a record at all. From 2016, even though you say it's not much use being in Band D, you are at least on the list, and therefore at that point, assuming they think it worthwhile at least to get into Band D, you will have a list of all those in Band D.
Yes, there was a 3-year period where, if my Lord's assumption is correct, then there wouldn't necessarily be accurate data showing how many refugees were deterred from applying because they knew they wouldn't qualify. But prior to 2013, that wouldn't have been the case. And in 2013, there was no explicit consideration of refugees at all, and such consideration as there was of persons, non-UK nationals, did not identify in that numbers. It was that single line that my learned friend took the court to, where it was simply describing the rule.
I'm sorry to ask you lots of questions and put you off your course, but you have flagged up before that you are able to show us figures that show that refugees will be a high proportion of eligible and qualified non-UK nationals. Is it convenient to do that now, just while we're on this general area of numbers?
It's at paragraph 55 of my skeleton.
based on various hypotheses as opposed to on figures.
Well, yes. We're not in a position to gather figures, but
Do persons from abroad in the 1996 Act include EU and EEA nationals?
only ones which are exercising treaty rights. So if we look behind tab 2 in the authority fund,
Yeah. They are subject to immigration control.
the short answer is that, if I can just put it this way, and then I'll attempt to answer it in a slightly more detailed way, that insofar as an EEA national is exercising treaty rights, they have the right to reside, which means they are eligible. A precise mechanism whereby the regulations achieve that is not on my tip of my tongue, but
And I was just wondering whether non-UK nationals is the right group for the protected characteristics, or is it non-UK stroke EU stroke EEA nationals?
well, for the purposes of establishing the difference of treatment between UK nationals and non-UK nationals, it's the fact of being effectively a person from abroad generally, which is the reason for the difference of treatment, because of the probability they won't have lived in the UK for 10 years. I don't, on my feet, believe there would be a way to then further distinguish non-EEA nationals, say, for UK nationals from UK nationals. That's the direction of my Lord's question. My Lord, the next point I wanted to make was a point about the nature of this challenge, because I think it's likely to be important, particularly if the court is of the view there's anything in my learned friend's point about the relevance of potential provision under Part 7 for the affected groups in this case. In my submission, it doesn't have any relevance to the discrimination in this case. Which I'm just going to flag, if I may, for the time being. I may, in due course, perhaps in the reply, if I have to explain it more fully. The sort of really overarching point is that it's very difficult to see how discrimination in the context of the allocation of social housing, so social commodity A, can be offset by rules in a different scheme altogether, allocating a different thing, which is housing assistance for homeless people. There is no precedent at all for a court looking at justification in that way. And indeed, in the case of Morris, Lord Justice Sedley dismissed, or rejected, I should say, a similar argument which sought to say that potential provision under the Children Act offset the discrimination in Part 7. But even be that as it may, I wonder if I could just ask the court to turn up the scheme itself, which is behind tab 9 in the joint agreed bundle.
Which bundle?
It's the joint supplementary bundle, Lord, and it's the scheme which is behind tab 9.
Tab 9, yep.
Tab 9, as my Lady Justice King observed, the scheme, as we've seen it since 2013 and in 2016, was at its heart a scheme which was designed to get rid of, if you like, people who had no housing need at all, and it achieved that very successfully. And the principal mechanism whereby it achieves that is a rule which one sees, and my learned friend took the court to it briefly, at page 174, rule 221, which is another disqualification rule.
Where are we going? Sorry, on page 174.
So I've just taken the court to this to demonstrate that this is the mechanism used to keep people off the scheme who don't have any housing need. And this rule, of course, is not under challenge. So nobody is suggesting, I'll get there in the end, I'll explain why I'm making this point if I may. Nobody is suggesting that refugees or travellers without a housing need should be going onto this scheme. It's only going to be refugees and Irish travellers with a housing need who are going to be on this scheme, because there's no challenge to that rule. The challenge is about what happens once you're in. And it's once you're in that the 10-year priority rule has such a dominant impact. Just going with Mr. Justice Mostyn's figures for a moment, at least over half of the allocations are based on the fact people meet the rules. So it's a very significant factor in determining ultimately where the allocations go. And whilst it's absolutely right to say that the particular applicants in this case establish their housing need by reference to the fact that the homelessness duty has been accepted in relation to them, it doesn't necessarily follow that that would be the only way in which anybody who's a refugee or an Irish traveller would establish that they have a need for housing such as would get them on the scheme. And we've had a lot of explanation from the borough as to why the decision was made to put homeless families in a new Band D, reflecting the fact that they enjoyed the benefit of Part 7 accommodation. There is no challenge to that decision. That's not the focus of this claim. The focus of the claim, in part, is that the borough didn't put every homeless family in Band D, it only put those who can't meet the 10-year residency requirement in Band D. So once you're on the scheme, the 10-year rule cuts right across it, no matter how you get there. And therefore, if you're disadvantaged by that rule, then it applies irrespective of the mechanism, or sorry, the basis upon which you establish your regional preference. So it can't be an answer to that discrimination to say, oh, well, we let you on the scheme in the first place by reference to the statutory obligation. It just doesn't work that way. Where the focus of the
This
challenge...
is because if you have lived in the borough for 10 years and are then made homeless, you automatically qualify for inclusion on the scheme, and if you satisfy the 10-year requirement, you go into Band C, B or A.
Exactly, yes. And if you're not capable of meeting that 10-year requirement...
Even though, as homeless, you, like a refugee or a traveller, have enjoyed the Part 7 benefits in the interim.
Exactly, my lord. Exactly. And that's why it's still a discriminatory rule. And cannot be offset by the fact that you're entitled to Part 7 accommodation. And it's also the reassurance the court might perhaps need that these claims are not about giving some kind of fabricated reasonable preference to these particular groups. That's not what this is about. It's just about treating them fairly once you're in the scheme. My lord and my lady, I just wanted then to deal finally with the Ahmed decision behind tab 9. The reason I'm taking the court to this authority is because it was relied on by my learned friend for the purposes of establishing through paragraph 15 of Baroness Hale's judgment just how careful the court had to be in the context of an irrationality challenge.
Yeah, well, the policy's still got to be lawful. They say so.
Yes, in paragraph 40. In particular in relation to discrimination. So, and the beginning of paragraph 15 makes clear that it's not in the context of discrimination that Baroness Hale is making those comments, it's in the context of a rationality challenge.
Yes, well, Lord Newlogan makes the same point at 37.
Great. I mean, I don't, for a moment...
Subject to complying with the provisions of section 167, subject to rationality and compliance with any other relevant legislation, terms and application scheme.
Yes, I mean, obviously, we all agree, and I'm just going to take the court to my final authority on this for the time being, that where appropriate, deference needs to be shown to the decision maker. And before long, we'll be coming on to the submissions of Mr. Gullu as to why that's not easily done in the context of this case.
I mean, in a way, the reluctance to, so to speak, rewrite policy, which their lordships and ladyship have expressed, may go to the question of the remedy. If a court comes to the conclusion that the scheme as it now stands is unlawful, it should not be in the business of suggesting things that might make it lawful, because that would be
My Lord, and that's why I was hesitant earlier in relation to my Lord the Vice President's questions about where to go with this, because I didn't want to fall into a trap of saying, oh, well, it must be this that the court must do, and this is the only way to remedy the problem. But at the same time, I obviously acknowledge, and it's directly relevant to the authorities, that if I was unable to say anything at all about what alternatives might be available, that might be consistent with a submission by my learned friend that that's because there isn't any. That's not my view, it's just that it's not Mr. Gullu's position to say which one, and of course neither is it likely to be the court's view as to which one. There are many cases like Tagari and others which are in the authorities which all say the same thing. And all that's been asked for by my learned friend Mr. Wise and I are declarations, such as was made by Mr. Justice Underhill in the context of Irish travellers, that this rule is discriminatory because it causes discrimination, difference of treatment, which is unjustified, and therefore the borough need to think again about these discrete groups. It does not, of course, strike down the rule. It does not mean the rule can't be applied generally to people who don't fit that class at the moment.
And presumably, it also does not prevent Hillingdon from justifying the rule as it stands with different evidence.
Absolutely.
If your complaint is that the evidence thus far hasn't justified it,
Absolutely not. Absolutely not. Were Hillingdon to go away and go safety valves, we got that wrong. We were putting forward a defence that didn't really work in law. And I'll come on to, I hope, explain why that's the claimant's position. Now we look at this differently. Now we think, okay, will this undermine the rule? How many are we talking about? What's the likely impact? What kind of measures would honestly reflect the connection that such a refugee may have established with our area, but which doesn't do away with the requirement that they should be able to establish a connection of some sort? And the guidance, interestingly, I don't want to go too out of turn here, but the guidance speaks very much, the guidance which supports the introduction of residency requirements, speaks very much about people being able to demonstrate a connection with the area. And it's not irrelevant that Hillingdon have chosen the strictest residency requirement in the country.
Is there evidence to that effect?
It's not disputed.
I think Ms Morgan says that, I think. One of the witnesses says it, I think.
The closest is one, I believe, that's 6 years long, but the majority are closer to the recommended minimum in the guidance, which is 2 years. I was just going to finish on that point about Ahmed, to go back to what Baroness Hale says about when you're looking at discrimination in the context of a socio-economic measure, but so as to try and not overburden the court with authorities, believe it or not. I haven't got the original authority, I've just got where it's cited in the Court of Appeal decision of DA versus Secretary of State for Work and Pensions behind tab 48, where it's actually being cited by Lord Justice Underhill in this court, in paragraph 180. It's tab 48. And in particular, I had in mind paragraph 160 from Baroness Hale's judgment in the JS case.
Sorry, what are we're looking at paragraph 160 of what?
It's paragraph 160 of Baroness Hale's judgment in JS's case.
Well, I thought you said you weren't taking us to JS's case. I thought you said you were taking us to DA as a way into JS's case.
I am, sorry.
So where do I find it in DA's case?
Paragraph 180. I apologise. I apologise.
Do you want us to read 160?
If I could invite the court to do so, it'd be great.
Well, I'll read 159 as well, to get the context.
Most grateful. JS is in fact in the final.
Yes, I thought it was.
I'm sorry, that wasn't at my request.
Yes.
I'm most grateful. So, my lords and my lady, those were my sort of opening observations. They've taken a bit longer than I anticipated, but it may be because we've already dealt with some of the issues that I was inevitably going to be asked about anyway in the context of the ground. The first ground, and I'm now reading from my skeleton, is paragraph 48.
Will you actually want us to refer to yourself? And you could do it that way.
It
makes it sound
easiest,
good.
yes.
Yes, certainly, yep.
ground of appeal contended that Mr. Justice Mostyn's finding that there was no relevant difference in treatment that required justification was wrong in law because he'd misapplied, at the very least, Section 19 of the Equality Act.
Well, as it's conceded, do you need to add to your written skeleton?
No. I was merely taking the court to it to make two observations, if I may, about that, both of which are relevant to the outstanding issue, which is justification. The first is that, in my submission, the learned judge's approach to difference in treatment, being wrong in law as is now conceded, also renders his determination of justification wrong in law. Because what he's seeking to justify is a difference in treatment, which he hasn't actually acknowledged or made a finding in relation to. And I make that point because when we look at the decision of Mr. Justice Mostyn, we see the first thing he gives saying it's justified is what he perceives to be the very slight difference in treatment, but it's the difference in treatment he was observed to be present. Only because he's taken the wrong approach.
Are you about to refer us to a particular passage?
I'm about to, yes, I do apologise. I've just taken that out. I'm now trying to go from the report.
Is it para 25 you have in mind?
Paragraph 25 and 37, I believe. I'm most quick on my notes.
So your point on 25 is that the judge comes back to his analogue here.
Yes, and so and then at 37 he says, well, look, the difference is so slight, it's quite easy to justify. I'm paraphrasing.
Yeah, so he's got to.
And the second point I wanted to take from the context around ground one was relevant to justification 2, which is the borough's approach, which I'm just going to explain in terms and then take the court to the documents if I may. That when this claim was issued, the discrimination challenge was as it's articulated now. It challenged the residency rules and said that they caused persons from abroad, non-UK nationals and refugees, a difference in treatment or disadvantage that was not justified. And the pleaded case of the local authority was to say there is no discrimination, and they relied in particular on one of the exceptions, fleeing violence, contained within 2.2.4, which is the residency qualification rule, which in effect was a way of saying, even if the residency requirement causes you discrimination, there's another way in, which dilutes or removes that difference of treatment. And that was the borough's case. And then before the learned judge below, that case changed because of the decision in R.H. and Ealing, as my learned friend eloquently explained, because R.H. and Ealing said that the relevant PCP is the rule in issue, it's not possible to say on the question of difference of treatment, it's not possible to refer on the question of difference of treatment to the impact of the scheme as a whole. That's only relevant to justification. Why I say that is because it actually directly goes to the case that's now being advanced by the local authority, which is not one which says that as a requirement, a safety valve must actually ameliorate the discrimination in issue. It's enough that it's simply there, and then the scheme can be looked at in the round. But their starting position, and in my submission the only one that really would have any legal relevance if it were established on the facts, was the safety valve, one in particular, that had the effect of offsetting the disadvantage. And unlike the other safety valves, in terms of its description, you could see the logic of that. It was designed for people fleeing violence, and you can see that, well, that might apply to refugees, as the borough initially said it does, because they're fleeing violence, and there was a ready-made exception to the rule. The problem from the local authority's perspective is that in his submissions before the judge below, my learned friend resolved from that position and said, in fact, that doesn't work because refugees do not qualify through that rule. And that raises, in my submission, a very interesting problem for this court, because the starting position of the local authority was there's no discrimination here because of a rule that's designed to meet the particular circumstances of refugees and offset the disadvantage. Therefore, as a whole, there is no discrimination. Then after that, they have to accept that they need to look at the particular rule in question and say, okay, we do that, but we try to justify it by reference to other rules. But those other rules are not the ones the borough has ever said actually offset the disadvantage. So where we're left, if I understand my learned friend's submission, is it's simply not a requirement, evidentially or in principle, that the safety valve should offset the material disadvantage that the other rule in the scheme is now accepted to be causing. As a question of principle or evidence. And so that's why I'm just raising, in the context of ground one, how it is that the local authorities approach that question in the course of these proceedings to better understand what the defence now is on justification. And as far as I understand my learned friend's submission, it really comes down to this. It's inviting the court to accept that this difference of treatment can be justified, even though it's not an obligation on the local authority to assess the difference of treatment between the person sharing the protected characteristics and those who do not share it, because in terms, my learned friend said, in the context of Irish travellers at least, it wasn't necessary for the impact on Irish travellers to have been considered, alongside a safety valve which is not designed and cannot be evidenced as meeting the disadvantage either. So you have a defence based upon an assessment of differences of treatment which are not the ones in issue, and safety valves which do not address the difference in treatment in issue. And that really is what my learned friend's case, if I may respectfully say so, comes down to. It's inviting the court to accept that that's enough. And in very simple terms, in my submission, it simply cannot be as a question of principle, because if you're not offsetting the difference in treatment by reference to other rules in the scheme, what is the relevance of those other rules? My learned friend said repeatedly that the court is obliged to have regard to the scheme as a whole, which, with respect to him, in my submission, is to misrepresent what was decided in RH versus Ealing. The court isn't obliged to do it. The court will do it if it's invited to do so as part of the justification defence. Of course, and nobody would have disagreed with that. That was certainly never Mr. Gullu's case. But the facts of the matter are that the particular criteria advanced by the local authority, as I've already canvassed, do not address the discrimination in issue.
You could justify the discrimination, presumably. And as my Lord Vice President said, you can say, well, there is discrimination, but the greater good outweighs it.
Yes.
I was thinking of another example in the special provision for people fleeing from domestic violence disproportionately benefits women. But you would justify it simply by saying, well, the men who are excluded, there's a good reason for it.
Yes. All of this is possible. But we're examining the defence that's put forward.
Yeah.
Which, as I've said...
But I think your point is that the way that Hillingdon have put the defence is to say that the so-called safety valves offset
Yes.
the difference in treatment.
Yes.
your point, as I've understood it, is no, they don't, because they apply equally to everybody and don't eliminate or mitigate the particular difference in treatment of which you complain.
Well, save that I don't know if they're applied equally to everybody, but I have no reason to disagree with that. The second part of my Lord's observation is correct. And so what is the relevance of the safety valves?
Well, just test it this way. Suppose if they've chosen, in a sense, to categorise their overriding discretion into a series of safety valves, but whether, as a result simply of the overriding discretion, they said, and it could be established, well, of course, we see the particular difficulties of refugees because of the points which you've referred to. And although it's not formally in our policy, if any refugee comes to us and relies on the particular difficulties they have as a non-national in general and a refugee in particular, we will exercise our discretion to move them on to Band B. That would work, wouldn't it? But it would work you would say because it wasn't really a because it was a safety valve directed to the very disadvantage which you said you were suffering from.
If he could demonstrate it either by reference to its terms or by reference to evidence, then it would be up to me to explain why that was not enough, if indeed I could.
Yes.
But we don't get to that stage.
What I was just trying to tease out is that it's not probably, I think it's too extreme a position, and I don't think it's the position you're taking, to say that a mitigating circumstance cannot be relied on by way of justification for a prima facie discrimination. Unless it is actually framed as directed to the very factor which leads to discrimination in the first place. A more general safety valve could, in principle, give a justification, but provided it was shown that it would mitigate the particular disadvantage complained of. Is that
My Lord,
fair?
absolutely. It's certainly not my position that unless there's a specific exception which deals with every refugee precisely, this is a discriminatory measure, i.e. an unjustified measure. Not at all. That's why I opened in the way I did about remedy. I don't say that even applies to the whole class of non-UK nationals, but it's got to be a real safety valve. And this might be where Lord Kerr's comments in Rebreast have become really relevant, because this is an ex post facto justification. It's not just ex post facto, it's really, it didn't even appear in the grounds of defence. That was based on a different safety valve, which the authority subsequently accepted and applied. So it's a completely new argument, if I may say so, which this hardship provision in particular, it's the only one actually identified, would somehow operate as a general exception, but it doesn't, because in its terms it doesn't say so. It's about hardship. This isn't about hardship. The examples given are nothing to do with the circumstances refugees or Irish travellers face. And then it's hardly surprising that the evidence shows, unequivocally.
Well, correct me if I'm wrong, I don't think that Hillingdon's evidence addresses refugees at all.
It does a little.
It does?
I can take the court to it.
Right.
It's in the Gullu supplementary bundle.
Yeah.
And it's behind. Just have one minute. So this is a statement produced on June. Sorry, I do apologise. tab 10.
Sorry, which one?
This is the Gullu supplementary bundle, not the joint supplementary bundle. And it's the third statement, so although it's not described as the third statement from Ms. Murphy, dated 9th of June 2017.
Which of the paras you say it's addressed a bit?
It's addressed a little bit in paragraphs 26 and 27.
26.
And
26
25.
and 27.
25 as well.
25, yes. I do apologise.
Yes, I must say I hadn't read this before. This feeds into something we were asking earlier about numbers.
Yes.
Yes.
Right, so none has gone banding under the hardship provision.
No. And if we look at the hardship provisions in the actual scheme, oh, it's behind tab 9. Oh, sorry. Yes. Tab 9 in the joint supplementary bundle. Page 30.
196 and bundle.
My lord. And I would invite the court to read, before getting to the examples, the actual description. We get a little bit more help about the circumstances beyond the examples given there. I'm sorry for taking us back to the statement of Ms. Murphy at paragraph 21 of that statement.
Yes. I see the time.
Oh, yes.
As I say, I have to be somewhere else at 4:30. As indeed does my lady. Now, I'm not in any way being critical, no more than I was Mr. Rutledge, but you've got quite a lot of ground still to cover. This is all, in a sense, that you're dealing with the points peculiar to your case. On the Equality Act, which we've heard quite a lot about already, you've still got to break some virgin soil as regards the PSED and your Article 14 case. How long do you think that's likely to take? Have you nearly finished on the Equality Act?
Yes, the remaining points I need to deal with, which I think I can deal with fairly quickly, and they're set out comprehensively in the skeleton anyway, is the three authorities are relied on safety valves, which in my submission don't support my own offence case, that it doesn't matter if they tailor to a particular discrimination in issue. Then I would need to deal quickly with what's said by the Borough about assessment of the discrimination in issue at the time the rules were formulated, which will take very little time, I would hope.
Well, you don't need to but let's see, so you've got some more ground to cover on the Equality Act, this bit of the Equality Act, and then you've got the Public Sector Equality Duty and Article 14.
On the public sector equality duty, it may be that between my learned friend and I, the HRC can cover some of
Well, let's see. I think, again, the right thing to do is just to flag up that we are still behind time. We may not be really because of the time that Mr. Rutledge is acknowledged he has to give up. But I think you need to give some careful thought as to how we're to cover the rest of the ground in the time available.
I will do my very best to get it done within 30 minutes in the morning.
Wow. Well, that will be impressive.
I'm going to try.
Very well. Can I just flag up one point for the Commission? Speaking for myself, but I think also for my lady and my lord, we found your supplementary note very fair and helpful, but I at least still need some help on what difference the paragraph in Lady Hale's judgment to which you refer makes. What's the distinction she's drawing? So can you make sure you cover that in your half hour alongside all the other material that's going to be dumped on you by Mr. Burton? Right, 10:30 tomorrow.